Good evening. I'm calling the session of the Stevens Point School Board special session on January 28th. Roll call.
Ms. Baker?
Here.
Mr. Ebel?
Here.
Ms. Erler?
Here.
Ms. Faxon?
Here.
Mr. Kokonowski?
Here.
Mr. Presley? Ms. Scott?
Here.
Ms. Sherrick?
Here.
Ms. Totten?
Here.
8 members present. We have a quorum.
Thank you. We are a board of education. That makes us unique from other boards in many ways. In part, it's because of who we represent and what our goals are. We're required to be fiscally responsible, be up on policies and new legislation, even as it's in process or continues to change. We're also required to provide a vision for and govern a huge machine by combining our own thoughts and ideas with the thoughts and ideas of 8 other people that we didn't choose to work with, we have no authority over, and without any black and white rules in place. We're governed by the law, public opinion, and one another, all for the ultimate goal and heavy responsibility of providing the best education possible for our children. Being the chair of this group is a difficult place to be, and that I too have no authority other than to constantly try and judge when the line of our policies or law is being crossed. Sometimes I get it right, sometimes I don't. However, it's been my experience that this board frequently challenges the line. One of my jobs as chair is to ensure that we don't cross it. As a result, I weigh each request as it comes. I look over policy and consult with legal counsel to determine what's fair and what isn't. I regularly hear about the gravity of what we do and the consequences of violating state or federal law. Several times I've heard, "I don't understand. Why would someone even do that?" Or, "What does that have to do with governing a school district?" And, "Well, no, it's not technically illegal, but it sure isn't a good idea." Being the person behind the scenes means that I witness firsthand the consequences of actions that push the line and walk right up to the edge of legal and ethical lines. It creates unnecessary risk for our district and taxpayers. We all bear the responsibility of our actions as a board. I've tried my best to convey to the board, individually and collectively, the advice I'm given without imposing my personal beliefs. This group of 9 people, who are all in this together, whether we like it or not, spend way too much time walking the tightrope of ethical and legal behavior. One of those areas being confidential communication. Our reputation in our community and beyond is labeled as dysfunctional, and we all know it. I believe the first step to resolving that is for everyone to understand that it's time to take a very large step back and look from a broader perspective what our duties and obligations are as a board. We're a board that governs a $100 million budget, 1,000 employees, and 7,500 students. We serve a very well-respected, well-rounded community. It's time to represent them as a whole with dignity and respect. In particular, as employers and as educators, we receive on a regular basis confidential information. It's one of our duties to protect that confidential information, and there are ramifications if we don't. Because of that, after a lengthy conversation with Mike Jilka, we have agreed that Steve Zock is going to come and address us this evening. He's an attorney with Boardman & Clark.
Thank you, Angel. My last name is Zock. We practice that a few times, and I understand that there's Zocks in this area, but I'm not related, I don't think. We're from the Bohemian area of Slovakia and Czechoslovakia, so I've been asked that before, but I don't think I've any relation up here. I'm a partner at Boardman & Clark in Madison. I've been there for 32 years. My area of concentration is in the area of labor and employment law and municipal law and school law. So for over 25 years, I've in particular represented municipalities, school districts, police commissions, utilities, in all aspects of their relations. In addition to that, I'm a sitting school board member, so I sit in your spot. I've been on the Oregon School Board for 16 years, up for re-election this year. We got good news this week. We were a very happy board this week because we got a $54 million bond referendum approved in November, and on Monday our bonds went out for sale, and we got them at 2.83%, which was like an amazing feat for us. So we're really happy. One of the things that I do at Boardman and Clark, because of my board experiences, I talk a lot with boards about their duties and obligations. I talk to them a lot about confidentiality issues. We've had those internal hard conversations on our board in Oregon over 16 years, and it's always helpful to go back and understand and refresh what our duties are with that. And I think to fully appreciate what the ramifications are if you breach those duties, because they are not only significant to the district that you represent and the taxpayers, but there's some really significant personal consequences that can occur if those confidences are breached. And I want to make sure that all of us know that. I have this conversation on a regular basis with boards that I work with that are involved in really sensitive personnel issues. And it is not unusual for me, at least once a month, to have this conversation with those boards, because we are in a unique spot as elected officials that we hold a fiduciary and public trust in terms of the information that we receive to be able to carry out the duties that we've been elected to carry out. That's a pretty significant burden on us as elected officials. So the goal of tonight is to do an in-service, and I would hope to be done within 30 to 40 minutes of that, to review with you, number one, the sources of confidential information that you get, the duty that you have with respect to that, and then to review with you the ramifications if you breach those duties, okay? So that's the talk. And we're going to talk not only in the sense of you as board members, but also with respect to employees of the district, because employees also get that sort of information. And we're going to talk about circumstances both in and out of official board meeting settings, because you receive confidential information from a lot of sources at a lot of different times within the district. Last week, as a board member, we have a closed session coming up next Monday, and I made an inquiry of our board president of what it's going to be about. And I've got a real brief idea what occurred, and that was a confidential communication, because I knew some stuff that wasn't going to be public because we were going to be in closed session, but was enough to give me an idea of what we were going to talk about. That was a confidential communication. That information was as protected inside a closed session and outside, okay? So, Angel, if I've got some handouts for the board, a copy of my PowerPoint and yeah.
Here, I can just do it this way.
See if I get this right. There we go. The first area that we get sources of confidential information derives out of the Open Meetings Law, 1985. The general proposition in this state is actions that we do as a board, together as a board in a properly noticed meeting, are for the public and for the public to observe. But the law recognizes that there are going to be some circumstances in which we work as a board where our communications aren't going to be public because of policy reasons, and therefore that those have to be confidential. Okay? So we start with this big notion that we function in the public, that we have to give notice of our meetings. They have to be held at reasonable times and reasonable places so that the public can watch us. But there, for policy reasons, are areas where our conversations need to be in private, behind closed doors, and kept confidential. And there is a list in the statute of times when we can go into closed session, and I've got those listed there. They occur when we act, for example, at expulsion hearings. okay? Or in disciplinary matters involving employees, okay? When we consider discipline or dismissal or the investigation of charges, we can go into a closed session at that time. If we're talking about promotion, performance, or compensation data regarding employees. Essentially, personnel matters are generally confidential when we're talking about specific individuals, and we have a right to go into closed session and have that conversation be private. Okay. Same thing when we deliberate with respect to the use of district funds, and we are in a negotiating stance, or we're thinking about investing and making some alternatives, and for the benefit of the district, it's better that we're in the preliminary stages of that those conversations stay private. When you bring us up as legal counsel, if we're talking about litigation or potential litigation, those are conversations that are confidential, okay? So we derive that out of open meetings law. What is interesting is that the Attorney General has commented about that in a case and said the legislature, in conferring on government bodies the power to hold closed meetings for certain carefully defined purposes, clearly intended that no one should have the right to report a closed meeting under the circumstances that might mean that its private and secret nature could be violated. This was a case in which someone wanted to bring a tape recorder into a closed session and tape that, and the Attorney General said, no, you don't have the right, and said, recognize the obligation that what is said in closed session must stay in closed session. Okay? As an obligation to do that. And for that reason, our firm, in communications out to our clients, has said the board should not make a written summary of the discussion conducted in closed session other than to record motions and to roll call votes, because that would be a public record that could be subject to disclosure. Okay? Open records law also conveys a notion of confidentiality. Again, the broad statement of the law is that records that we generate as a school district are protected, are open to the public, except again, there are areas where we can prevent disclosure and claim privilege over those as confidential documents, and those are listed up there. We get a lot of open records requests on behalf of our municipalities in terms of what is confidential and not, and these are some of them. Law enforcement records, computer programs, identities of applicants, and employee personnel records. There are specific information regarding employee handling that those records aren't subject to disclosure under the open records law. Okay? And again, this indicates not only the records, but if the records are protected, then information that we derive from them as board members and as employees are protected and confidential as well. In fact, when we do open records requests, one of the things we do is we walk through a bunch of steps, and the last step is to do a balancing test as to whether or not public disclosure outweighs the privacy or protected nature of the information. And one of the things that the Attorney General has said that when we look at this balancing test, the exemptions to the open meetings law serve as authority to not disclose a record. If it falls within the scope of why we would not have that issue in open session, that would also serve as a basis under the balancing test for not disclosing the record. Okay? And that creates an era of those topics that we've looked at in open meetings and open records are confidential subjects when they're in the hands of board members and employees. So those things and those things all are areas that carry with it an aura of confidentiality that we must protect, whether we have that in a closed meeting or whether we hear about it in our duties as a board member. We know through FERPA that school employees and officials, including you, can't disclose pupil records without written consent, and those include progress reports, behavioral records, pupil physical health records information about that. You know, it's a pretty, we do hours on FERPA stuff, but for your purposes and for the purposes of tonight, that's another source, a large source of potential confidential information that we receive as employees or board members. Those records have to be kept confidential, okay? They cannot be given to third parties without consent, and there's some very limited exceptions to that. Employment records and employee information, we cannot disclose unless authorized by the employee a bunch of contact or identifiable information, including home address, emails, social security numbers in employee evaluations, okay? There's a statute that isn't very well known out there. We call it the Privacy Statute Employment Law. It's 99550. And that prohibits, as a matter of state policy, the disclosure of information to other people about another person if it intrudes upon the privacy of another, if it's of a nature highly offensive to a reasonable person, and in a place that a reasonable person would consider private. There has not been a lot of litigation over this. But part of that is due to the fact that employers generally know that personnel records and personnel information has with it a degree of confidentiality and privacy, and that if those terms are met, that creates a statutory breach by the person who violates that duty. Okay? The disclosure of information that intrudes upon the privacy of another, that discloses confidential information about them, that's highly offensive to a reasonable person, that if somebody would be offended by that disclosure in a place that a reasonable person would be considered private, that is personnel files, personnel information, employment information, that gives rise to a potential cause of action under that statute against the person who violates it. Medical records. Sometimes we as board members see that in the course of dealing with employment stuff. Employees get that from time to time on a need-to-know basis. Both the American with Disabilities Act and GINA, which is the Genetic Information Non-Discrimination Act, treat any medical records as confidential. That cannot be disclosed, and there are very limited exceptions under that. Your district policy recognizes this. 161 says for board members that board shall govern the district according to all state and federal laws, and that includes the open records law and the open meetings law, the privacy statute, that you will not breach the confidentiality of privileged material that's before you. That's your district policy. 161. It says, individual board members have no authority over the district in their own right. The expression of the board authority can only be in the context of the board as a whole. Where this comes in significance with respect to this topic is that when you vote to go into closed session to talk about a privileged matter, you vote as a board. And when you vote as a board, your board is indicating, as a board, you will abide by the confidentiality of the information that you received in closed session and will not violate that. And that is an obligation that you have under Board Policy 167. You have no authority over the district in your own right. So if a board member would go out of closed session and disclose information that you learned in closed session, you're violating that policy because you only have the right to act. You only have the right to act in the context of board authority and not individually. And when you vote to go into closed session, that means that you as a board have bound everyone to confidentiality over the information you learn in that meeting. And then 165 hits this on the head, that you have an obligation under board policy to respect the confidentiality of the information that is privileged. Similarly, district policy creates similar expectations and duties to employees. In particular, under 2.04, employees are required to observe the code of conduct, which requires you to maintain confidentiality in appropriate matters relating to students and coworkers. Okay? It talks about personnel files in 2.21, that those are limited in terms of who can see them and in what context, and indicates that those are confidential and privileged. Your board policies for employees contain a specific policy on confidentiality, 2.05. And that essentially boiled down to, it says that information that you know that is confidential about students, family, employees must stay confidential. Okay? And a violation of that may be cause for disciplinary action up to and including discharge. Okay? So that's your own board policy. So as you've seen, we have sources of duties ranging from your general obligations running open meetings, generating public records, being employers, so you have a general employment right to hold personnel records confidential and information receive about that. You have FERPA that oversees you. You've got medical record confidentiality under the ADA and GINA, and your own district policy create sources of confidentiality and privilege. Okay? So those are your sources. Pretty broad subjects there. Okay? And it's one that we hold as elected board members and sworn board members that we have to abide by, else we violate that duty to the public. Any questions specifically about the legal sources of the duty?
I have a question
Yeah.
about the confidentiality.
Yep.
Does that apply to everything that is said in closed session?
Yes.
So if one board member, for example, attacked another or said something that could be deemed to be defamation of character or something like that?
My statement is what is said in closed session is in closed session.
So if they were concerned, though, something illegal, how would you have to deal with that?
One of my policies is I don't answer hypothetical questions, because that gets you in trouble on stuff, and
Okay.
I will render legal advice when I am requested that, and will get the facts that I need to do that. I hope you understand.
No, that's fine.
I don't know how guys do that on those call-in shows when you have when you have lawyers. No, they don't actually. I don't think. But they we've got those in Madison where they get stuff over there. I just, as my practice is not do. From a general source of confidentiality, when you go into closed session, that's closed session. Okay? And your board has said that what's said in there remains private. Okay? Within the context of the notice and what you're talking about.
Thank you.
Okay?
Question on
Reason.
the 995.5.
Yes.
That statutory breach, would that be an individual breaching it, or could it be a corporation or a district or a whole board?
The general way we've thought about that is that it's an individual breaching that, but I could see the application of that broader than that to take a corporate entity, for example.
And can that also apply to media then?
You'd have to, I wouldn't think so, because they have a different duty, and if you looked at the terms of that, let's go back to that. It's phrased pretty broadly, and as I said, this really hasn't been subject to much interpretation from the appellate courts on that. we look at that and say, it's out there, be careful about it. And there hasn't been a lot of litigation about that to really answer your question on that. But when you're talking about media and how you apply that, there's a lot of reasonableness that somebody would consider private, that the source has got to be from a private source, that sort of stuff. And whether the press falls, would you consider press getting information something that a reasonable person would consider private? I know that's up for interpretation, okay? This has generally been thought of in the context of an individual taking that information and doing that, though, okay?
Doing it meaning giving it to
Giving it,
anyone,
yes.
including the media.
It's intruding upon the privacy of another of a nature highly offensive to a reasonable person in a place that they would consider private. So if someone is violating that duty, okay, and applying those facts to that, that person would have violated that. Okay? And the particular circumstances under which that has occurred, there aren't a lot of cases out there that have reported on that. Okay? We just know as legal counsel that represent employers, including municipalities and districts, that this sends a warning shot out to you that there could be a private right of action out there, potentially. The parameters aren't terribly clear. Okay? Yes.
We have a few board members who feel very strongly that we as a board should not go into closed session for any reason, and that all matters before the board should be done in open session. And so my question to you is, as relates to 19.85, could you provide some background as to why the legislature determined that there were a number of exceptions for public bodies to be able to enter into closed session?
What I can say to answer your question is that there is a general preference and recognition that boards meet in open session. The legislature, as a matter of policy, said that boards can go into closed session in very limited circumstances that are defined by the statute and that are construed right now fairly narrowly by the Department of Justice. But there are those situations in which the public interest in hearing information is outweighed by the personal privacy and confidential nature of that, okay? How boards choose to apply that is in the nature of each board's decision to go into open or to go closed session or not. But there is that ability to do that, okay? And that creates an aura of confidentiality with respect to those subjects, okay? There are good reasons why you would go into closed session with those issues, okay? Any other questions about the sources of the duties? Yes.
If you're in closed session and you are the topic of what's being discussed, do you have a right to release that information, or it just can't leave no matter what?
It depends on the topic. Okay? You know, the closed session information has to be, your closed session has to be run in a manner that what's being discussed in closed session fits within the context of the exemption for open session. You've got to stay tightly to that you can only discuss matters that are protected by the exemption from being an open session. And that's what's protected. Okay. Any other questions? Okay. Let's talk about what happens if there's a breach. There isn't a lot of information in Wisconsin law about breach of open records or meetings in Wisconsin in terms of potential ramifications. Censure is one, and we'll talk about a couple others down the road. But there was some interesting decisions out of New York, and in particular their Commission of Education. This was one statement that came out of one of those decisions that hits upon this notion that if you disclose information from a closed session, that thwarts the will of the majority, contrary to the basic principles of school governance. That is, when you vote as a group to go into closed session, the will of the majority is that stays closed. And that we found that reflected in that decision, okay? And it reemphasizes that if there's an unauthorized disclosure, that breaches the member's fiduciary duty to the district by elevating a personal concern to take that information which was in closed session, which was the will of majority over the board's determination of what's in the best interest, okay? So that's one consequence. There's a felony statute out there that says this: any public officer or public employee who does any of the following was guilty of a Class 1 felony that subjects the person up to $10,000 of fines and potential imprisonment up to 3.5 years. And this says that if you are in an officer or employee, so it's both officers, that would be elected officials, or employees' capacity as an officer employee that does an act which the officer employee knows is in excess of the officer employee's lawful authority, or which the officer employee knows the officer employee is forbidden by law to do in their official capacity, that gives rise to a felony. Okay? That's pretty significant. That's the misconduct in office statute. There hasn't been very much litigation over that. Probably the most famous one was State Senator Charles Qualla was prosecuted under this. Okay, so we don't see it prosecuted very much. Okay, but you need to know it's out there. Okay, because it's potentially a problem that if there is a statutory breach of confidentiality, that this is potentially in play. That's fairly significant. That's from a criminal side. Sometimes we're asked the question, well, don't I have free speech rights to say what I want as a public official? For employees, this is different than board members. If you don't get protection for acts within the scope of your job duties, and so if you receive confidential information and disclose that, there's the potential that under the Garcetti case that would not receive First Amendment protection, and then it's only if it's a matter of potential public concern. So we're walking down the line to an argument that if you're breaching confidential information intentionally, that isn't a matter of public concern so as to obtain First Amendment rights to protect yourself from potential discipline or from a potential lawsuit. Okay? And even if it is a matter of public concern, then there's a balancing test that occurs under Pickering that we look at, and that is balancing the public concern with the interests of the board in promoting the efficiency of service. So from an employee standpoint, breaching confidentiality has significant risks that it would not be protected by the First Amendment. Okay. Board members, if you're expressing policy position and you vote, that's protected by the First Amendment, okay? But there's a lot of law out there that says that speech that constitutes a criminal act isn't protected, okay? So if we are breaching confidentiality, and we know that happened and that act occurs, that may be a criminal act, and that would not entitle one to the First Amendment protections, okay? And free speech protection doesn't block board members from censure for violating procedural rules or board policy. Okay, so when we get that argument about First Amendment, we say, yes, there are First Amendment protections, but in these sort of circumstances, there's a strong likelihood that arguments can be made that they're not going to apply to protect that conduct. Okay?
Steve, I have a question.
Yep.
So, under the third bullet point, it indicates a board member who knowingly acts outside of his or her duty. But am I correct in stating that that would apply to anyone who was in closed session? For example, the superintendent, the board secretary, any administrator who was asked to come in, et cetera.
That's right.
So it's not limited to board members.
Correct. In terms of applying the free speech test, in terms of whether it's protected.
As well as the confidentiality.
Yes. Yeah, the closed session, if people are invited into the closed session because they're integral to the topic that's being discussed, relevant to the reason why you're in closed session, that coverage applies to them as well. The requirement that it be confidential extends to them as well.
Does it extend to the board secretary, who is not necessarily an integral part of the discussion, but is there to record the vote?
Yes, I would say yes. Because, yes, that covers the reason you're in there by statute and by the board voting to go into closed session. That creates a protected nature of that conversation. Okay, so that's free speech. In federal and state law, if there's a lawsuit that's filed against the district and its members, board members, or employees, there is what is known out there, a defense called qualified immunity that protects you from suit because you're acting in an official capacity. All right? And we raise that in a lot of federal lawsuits that we get against districts and employees. That we would say that if it's an individual employee or a board member that's named, that they're protected by qualified immunity and not subject to suit or damage in that. Okay? There are exceptions to that, and that's lost when an official knows or reasonably should have known that the action within the scope of the official responsibility would violate someone's constitutional or statutory rights, or if he or she acted with malicious intent to cause a deprivation of a constitutional or statutory rights or other injury. We can envision a circumstance, a case that's filed that has aspects of it, a breach of confidentiality against the district and the individuals, and board members might want to raise a qualified immunity defense, which would be lost if that board member was involved knowingly in disclosing confidentiality or confidential information. Okay? In that case, school board member could be individually liable for civil suits. Right now, if you're acting within your scope of authority and not breaching any duties in terms of confidentiality, you have some immunity from suits. Okay? And you can raise that. If you step outside that line, that immunity goes away potentially. Okay? And that also means that you might not be covered by the district's insurance policy. So there's some very significant ramifications to board members who knowingly act in violation of someone else's statutory or constitutional rights. Okay? You could lose qualified immunity. Yep.
In this instance, the qualified immunity, I know that in some cases a spousal relationship is treated differently. Is that the case with regard to closed session?
I don't know the answer to that. And I wouldn't want to guess on that to see how that applies. I have not seen anything on that to see whether a spousal relation allows you to override the confidential nature of closed session. My I don't think it does, okay? That what you say in closed session doesn't go to spousal conversations. That would be my advice. We talk about that on our board, is that you don't talk about that with anybody, okay? Not even your spouse. My wife's a medical technologist. We don't talk about anything that she does or patients she sees about that. I think if you're in closed session, that same rule applies. I think even to spouse. I've not seen that articulated, that there's any case law on whether or not there's some spousal immunity. I don't think it would be. Standing here tonight, that there would be some exception to the closed session to talk to spouses about that. Okay. There's also I talked about qualified immunity, which is a court doctrine, but there's also statutory immunity under Wisconsin law for public officials. That's under 89380 sub 4. That you've got pretty broad protection by that statute, that no suit can be brought against the district or its officers, agents, or employees for acts done in your legislative, quasi-legislative, judicial, or quasi-judicial functions. And there's a lot of law about what that means. But if you're acting as a school board member in the normal course of your duties here, you're likely protected under one of those four, okay? That's gone if there's a finding that the action of the lawsuit of the individual was malicious, willful, or an intentional act. Okay? So that's one of the things that when we talk in closed session, and I know it's a sensitive issue and a hot-button issue with the board and with the community, I make it clear to the members of that board that if you talk about this outside and someone brings a privacy violation lawsuit against the district and you individually, you may not have statutory or qualified immunity from suit and could be sued personally for that without protection of insurance. Okay. Now, on all of this, I'm speaking in general terms, okay? I'm pointing out landmines to you. And the one thing I don't want you to do is say, aha, that fits to a specific fact situation, because all of these are factually dependent. The thing I'm trying to convey to you is that there are sources of highly confidential and protected information that you get, that there are duties to keep it confidential, and that there are landmines out there for you if you don't. And these are some of the landmines. How that gets applied in a case-by-case basis to any particular situation depends on that. And that's one of the reasons I don't get into hypothetical questions, because one thing I don't want you to come out of here with is saying, aha, 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 you're not immune, that's not it. I'm just saying, these are the landmines, these are the duties. Okay? And here's one that's really significant to you as board members, because when we serve, we have this immunity from suit that could be lost if we act maliciously, willfully, or intentionally to violate somebody's rights. Okay? Again, the privacy statute that we talked about, that could give rise to a civil action for compensatory damages and attorney's fees. And if you're engaged in an illegal act that meets those four categories or 4 bullet points on the privacy statute that we look before, you might not be with immunity, you might not be with insurance coverage, and might not have a district-provided legal services. Okay? Finally, the statute 1713 says that a school board member can be removed from office for cause. That's a complicated procedure that involves the filing of charges, and it has a hearing before a circuit court judge to determine whether cause is present. Certainly one could envision a scenario where the breach of confidentiality could give rise to a charge and an argument that establishes cause, which would subject someone to removal under 1713. Okay? There's not been a lot of activity on this, or case law on that, but it's out there. Same thing, there's the board can censure members for violating the duty of confidentiality. Okay?
Can I ask a question?
Yep.
The first one, a school board member can be removed from office for cause. Does that have to be initiated by the board? Can someone in the public initiate that?
Someone has to file a charge, and I haven't looked at it in a while. I'd have to look particularly about who can file that. But it involves the actual filing of charges, and then there's a hearing process that goes before a circuit court judge.
I'm just trying to, I didn't know if it was like board or...
I'd have to look at it.
Okay,
you know.
just curious.
Okay, and then finally, that deals with officials, your policies under 536-2 for staff in terms of if you violate policies or violate the confidentiality, that can give rise to termination or other discipline, and the standard for here is that's, as long as it's not discriminatory or prohibited by law, that's a disciplinary action that can take place. So it's a low hurdle. So if there's been a violation of confidentiality by employees, that can give rise to discipline up to and including termination, okay, under this standard. So, any questions? Yeah.
Question about this. I know that as elected officials, board members would not be subject to certain of the human resources or personnel policies and handbook and procedures that we have. However, board members are remunerated. Are they in any way, and if they are, in what way, employees of the district?
I don't, in terms of the board policy, they're not within this ambit. There's different,
Right, I
there's
understand.
different categories. Are they employees of the district? They're considered officials. And there are different standards in terms of, one could be an employee for one context in terms of reporting income and that, and not employees for another context. So it depends specifically on what you're talking about. In terms of the disciplinary policy, probably not, because you've got different standards here, and there's a specific standard for removal and discipline, okay? So in that context, they're not employees within the scope of this termination of employment under board policy, okay? Employees means different things in different contexts, okay? What I've tried to do by this is enumerate that, for employees like we think in the regular context, that is staff, teachers, et cetera, not board members, that applies. Your 536 applies. For school board members, we've got a specific statute that talks about how we terminate that relationship. That can be done under that for cause, okay? These talk about subject, these are different. These are legal risk in terms of if you're sued, can you be liable for damages individually? So that's what all this is about, walking through there. And then when you get to here, that's board member, that's employees. Okay. Any other questions about the breach of the duty? Yes.
Mike has talked to me a couple times about intent, and that there's some law that deals with the intent, that it's irrelevant. Can you explain that a little bit?
Yeah. I don't like reading Mike's mind because he's a lot deeper and smarter than me, even though we have the same hairstyle. Intent. If you're looking about the criminal statute, okay?
I think so. I think it was
that
federal.
intent is an element of that in terms of what needs to be proved, okay? In terms of a civil suit, there's probably some intent or a knowing disregard of rights. I think that's a standard that was set forth in there. So I don't know what Mike's talking about in terms of specifically which one of these.
Did you mean to break the law or not?
What?
He was talking about how we're held to a different standard, that it doesn't matter if the intent was, if you didn't understand what you were doing. one of the laws, it didn't matter.
I don't know what he's talking about in terms of the law. In terms of violating the open meetings confidentiality provisions, intent probably doesn't have to be proven as whether you knew or should have known that it's not disclosable.
I think maybe that's what it was.
the standard for that, in a reasonableness standard.
I think
Okay.
that's what it was.
Frankly, there hasn't been a lot of civil suits brought on this or appellate court decisions raised from the circuit courts that talk about this stuff. But there are dangers out there to watch, and the exact parameters are unclear in some areas, but the message is clear from all of them, is that when you're dealing in an area of privileged information, either as defined by the Open Meetings Law or by the Opens Records Law or by FERPA or other stuff, when you're dealing with that stuff, you got to keep it privileged. Because if you don't, there's serious ramifications to that. Not only to the district for potentially being sued, but you could be without protections as board members or employees if someone brings a lawsuit against you for that. Okay? And in the end, there's also the ability for board members to be removed, to be censured, for employees to be terminated or disciplined because of that. Okay? So that concludes what I have to say. The looks I get here are the same as I get in boards when I have this conversation. It's pretty serious stuff on it. Then they walk out and are pretty careful about what we say from then on. We have this conversation at least every couple years, and we have it with new board members when they come on our board, just because we deal with people who entrust us with confidential information. We have kids whose records by nature are confidential under FERPA, and we have a public duty and a public trust to create that confidentiality. And in the end run, if we forget about it, the civil liability stuff, and whether we could be criminally liable or civilly liable, and what economic ramifications flow out of that, any board works together needs to have this fiduciary relationship amongst each other, that you have the ability, willingness, and duty to keep what you say that is privileged as a board. Okay? At a bottom line. Thank you for letting me come up and talk to you
Can I ask
tonight.
a question?
Yeah.
When I look at your outline, in every one of these pages, you've got lots of information, breach of duty, statutory immunity, privacy statute. On this page, breach of duty, removal or censure, you have information listed, a particular statute listed, and then it says a school board can censure one of its members, and you have nothing there. Can you fill that out for us a little bit?
It's just the right that board members have if there's certain parameters established in terms of violating duties to censure, and that you need to get specifically from legal counsel depending on the circumstances. Okay? There's a specific statutory provision that deals with removal for cause but doesn't define cause and what grounds would be for that. That's subject to judicial determination. The same is true with respect to censure. That's board decision with legal counsel. So
that would have to be part of possibly our policy. If it's in our policies, then that would apply.
that's one way you could do it.
We don't have a policy on censure.
I don't see a lot of them, okay? That typically is on a case-by-case basis, depending on circumstances.
You don't need a policy.
Pardon?
You wouldn't need a policy.
I haven't seen a lot of them,
I haven't either.
okay? They just,
So what's the definition? What happens? I mean, explain it to us.
I would rather not do that because they tend to be case by case, fact by fact, depending on the circumstances of the conduct of the board member. Okay? And what has gone on. Just as I can't tell you what constitutes cause and how that's related at.
Sure, but I can look up cause in the statutes, and I can find a definition in a couple of different places. I'm looking for a definition of this and procedure and how that works.
You will work with your legal counsel to do that.
Okay. Thank you.
Okay? Just as you would work with legal counsel in any case in determining whether there's cause. You know, when we were under the collective bargaining eras and the contract said cause, we worked with our boards all the time in defining what cause is, because it differed depending on what jurisdiction you're in, who your arbitrator is, what the circumstances are. It varies under all those. The same thing with censure. Okay. Any other questions? Okay, thank you.
Thank you.
Thank you.
Thank you, you guys, for giving up your time tonight. I mostly wanted to get us on the same page. These are heavy things that I hear regularly when I'm asked to ask legal counsel about things, when things are brought to me. When I don't know the answers, this is one of the guys I ask, and these are the kinds of things they say to me, and it's very heavy. Knowing what can be said and what can't be said, and how serious this is, and how seriously we have to take it. So, thank you for being here. Thank you for your attention. I would take a motion to adjourn.
So moved.
Second.
All in favor?
Aye.
Any opposed?